Hello everyone, welcome back to Madad IAS. This is video 12 of direct sources of each questions asked from polity in UPSC CSE in the last 20 years, specifically from Lakshmikanth book, which is our main source of preparation. Here you will find marked chapters and page number wise questions along with the screenshots attached. If you don't know what exactly we are doing here, I would ask you to please go ahead and watch the 2005 video. It'll give you a fair idea of what exactly this series is all about. Now, for all the people who were asking that why there was such a gap between all the videos, I really wanted to do this for 2025, but with my own commitments and my own job, I have a full-time job, I could not do it. But going ahead, we are going to be completing this series, and first we're going to wrap up polity, and then we're going to do CDS and CAPF questions for geography. Starting with this question from 2016, topics is bills. Which of the following statements is or are correct? A bill pending in Lok Sabha lapses on its prorogation. A bill pending in Rajya Sabha which has not been passed by the Lok Sabha shall not lapse on the dissolution of the Lok Sabha. Now, this question you will find in chapter 23, page number 236 and 237. Very clearly, there is a comparison table here given which tells us the differences between adjournment and prorogation. If you look here in prorogation, it clearly is written here. It also does not affect the bills or any other businesses pending before the House. However, all pending notices only the notices are lapsed, not the bills. So statement 1 becomes incorrect. For statement 2, we go to page number 237. Now here, if we see the position with respect to lapsing of bills is as follows. I think the point number, point number 4, a bill pending in Rajya Sabha but not passed by Lok Sabha does not lapse. So here, second statement is correct. Our answer becomes B2 only. Coming to question number 2, the topic is Chief Secretary. Now, this particular topic is not given in Lakshmikanth, and it has not been asked very much in UPSC, like only 1 or 2 questions have come from this topic. So, let's just do it. The Chief Secretary in state is appointed by the governor of that state. The Chief Secretary in a state has a fixed tenure. Both these statements are incorrect. The Chief Secretary is chosen by the Chief Minister, and the appointment is an executive action of the Chief Minister taken in the name of the governor of the state. The Chief Secretary does not have a fixed tenure. So we can remember this for further questions. Again, okay, so there's a typing mistake here. There's a 2016 question only. Topic is Lok's Adalats and other courts. With reference to Gram Nyayalaya Act, which of the following statements is or are correct? As per the Act, Gram Nyayalaya can hear only civil cases and not criminal cases. The Act allows local social activists as mediators and reconciliators. Here for this, we go to chapter number 38. Let me just check. Yeah, so chapter number 38 is Lok Adalats and other courts. Under the heading Gram Nyayalaya and its features, we find this answer. If you see here, the salient features of Gram Nyayalaya Act as follows. The Gram Nyayalaya shall be a mobile court and shall exercise the powers of both criminal and civil courts. So statement 1 becomes incorrect. It has powers of both criminal and civil courts. While the second statement is not directly given in the book per se, but this is correct, that social activists are allowed as mediators and reconciliators. Going to question number 4, the topic is center-state relations. Now, the question is, the Parliament of India acquires the power to legislate on any item in the stateless and national interest if a resolution to that effect is passed by. Now, this particular question, we find the answer in chapter 15, Center-State Relations, page 146. Under point number 3, Parliamentary legislation in the state field, part A, when Rajya Sabha passes a resolution, if the Rajya Sabha declares that it is necessary in the national interest that a parliament should make laws with respect to goods and services or taxes in the matter of state list, then the parliament becomes competent to make laws on that matter. Such a resolution must be supported by 2/3 of the member present and voting. The resolution remains in force for 1 year and can be renewed at any number of times, but not exceeding 1 year at a time. The law ceases to have effect on the expiration of 6 months after the resolution ceases to be in force. Just 1 second. And this is technically article number 249 of the Constitution, so it's directly from the Constitution as well. The answer is D, Rajya Sabha by majority of not less than 2/3 of its members present and voting, given here. Coming to the next question, the topic is Panchayats. The chapter is chapter 39, Panchayati Raj. Page number 389 and 390 have our answer. The minimum age prescribed for any person to be a member of Panchayat is 25 years. A Panchayat reconstituted after premature dissolution continues only for the remainder period. Very clearly, it is given here. Just a second. So no person shall be disqualified on the grounds that he or she is less than 25 years of age if he or she has attained the age of 21 years. And for the second thing, duration of panchayats, point B, in case of dissolution before the expiry of a period of 6 months from the date of dissolution, but where the remainder of the period for which the dissolved panchayat would have constituted is less than 6 months, it shall not be necessary to hold any election for constituting the new panchayat for such a period. So this is true that it is going to continue after that. Moreover, a panchayat constituted upon the dissolution of a panchayat before the expiration of its duration shall continue only for the remainder of the period for which it is dissolved. So the second statement becomes correct. Our answer becomes 2 only. Coming to the last question, the topic is Act of 1919. Montagu-chelmsford proposals were related to social reforms, education reforms in police administration, constitution reforms. This is something that we read even in, I think the page numbering here is a bit off. I think this is in chapter number 1, historical background. Under Government of India Act of 1919, we know that it is a constitutional reform. So the answer becomes D. Very few questions were there in 2016, only 6 questions. So the next video 2017 might have a lot of questions, around 19 to 20 questions, and I will be uploading that very soon, probably today or maximum by tomorrow. Thank you.